Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides.
Here we go. Motion for mistrial based upon judicial and prosecutorial misconduct and thus bar retrial. Okay, let's get into it. What is Brian saying? Comes now, Young Thug, by and through undersigned counsel, hereby files this motion for fair trial, as well as a motion for a list of dates/persons who participated in any ex parte communications with the court and the topic of same. All right. Motion for mistrial based on judicial and prosecutorial misconduct and thus bar retrial in the above referenced case. In support of this motion, Young Thug shows as follows. All right. We're going to zoom in on this one. We want to make sure we don't miss anything. All right. Mr. Williams, aka Young Thug, is innocent of all crimes in the above referenced indictment. From the inception, this trial has been constitutionally unfair, as this court has failed to be impartial to Young Thug or his counsel and has been objectively biased in favor of the prosecution. Some examples of same include, but are not limited to, the below. All right. First of all, they want to make a point and say during, I believe this is opening statements, Lawyer Love misrepresented the demeanor of the jurors to attempt to have the court excuse for cause potential jurors. Lawyer Love did not want to serve on the qualified panel. The court did not admonish the Lawyer Love for these misrepresentations. Undersigned counsel does not have a transcript and cannot locate YouTube video/audio of the trial on these points. All right. So they're laying out already. They messed up. All right. Let's see. So what are they saying here? Some examples of same include, but are not limited to. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin Monday, November 27, 2023. Thug's been in there a while, y'all. So that objections could be made prior to the presentation of opening statements. All right. And to see YouTube dated here, and then they give a timestamp of a minute. Y'all want to check this? Y'all want to check this out real quick? Let's see what they're talking about, because it's only a minute. So we should have enough time. Let me see. Let me go back here. All right, let's see what Brian Steele is talking about.
Just a sort of cursory review of this.
And he said we need to go to
covered in notes, scribbles, and just in the first few pages, highlights. And so, to the extent that it's
15,
been altered, we also have that objection.
Mr. Harvey, I'll admit it as D1, but you need to give us a clean copy.
The rule of sequestration, because we intend to invoke it. Does this honorable court invoke it? The law says it's when the witnesses start testifying, but do you have a preference before opening statements or not?
Mr. Steele, I usually invoke this rule C accordingly.
Here we go. Let's skip forward a little bit.
The rule.
Okay. Yeah. All right. And then the second thing is, can we agree? I'm asking the court because, as the court, as the power, can we exchange, if it's okay with the colleagues too, any type of exhibit that we plan on using in opening, so we don't have to delay the jury? Because
yes, that would be wonderful, because then we won't have objections and other things that would be otherwise disruptive. And I think that the smoother,
all right, Brian Steele's backing it up,
the better off you'll be. But like I said, there shouldn't be too many at this point. There shouldn't be too many surprises with anything. But I would say that would be the best thing to do.
Okay.
So that we don't draw any objections. So I think that would be proper. Ms. Love, do you think you all can do that?
that okay?
Yes, we will submit any, any pictures or any photographs or anything of the light that we would like to show.
I think you all can, I think if you all did that.
Yeah, she said, yeah, whatever. I mean, sure, Judge. I'm not really going to do it, but yeah, whatever you say. All right. On Friday, November 24th, 2023, Lawyer Love shared her purported demonstrative aid via email. During opening statements, however, during opening statements, Lawyer Love showed a completely different, never before seen demonstrative aid, which was in clear violation of the court's order. Come on, man. Brian Steele was heated too. So they tried to pull the okie doke on him. The court denied Young Thug's timely motion for mistrial, and there was no consequences meted out by the court for Lawyer Love's intentional misconduct. Yep, they just let it slide. And y'all noticed throughout this trial too, and I think Brian Steele probably saw this early on, that anytime the state or anytime Miss Love or ADA Hilton did something, Judge Glanville would kind of say, it's fine. Everything's been messed up. Or anytime Judge Glanville and things got out of hand, he would say, oh, well, it's in the heat of the moment. It's okay. Things happen. But the minute Brian Steele gives any pushback, this man gets held in contempt. Crazy. During the same opening statement, Lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in this case. Wow. Specifically, during her PowerPoint presentation, Lawyer Love highlighted to the jury that undersigned counsel represented co-indictee Blalock. I'm saying that name wrong, I'm sure. Again, there are no consequences meted out by the court, of course. All right. And in this video clip, Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that witness Miss Bean was taken to Grady Hospital by police directly from the scene of his arrest on September 11, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence as Mr. Bean never went to Grady Hospital on September 11, 2013. Lawyer Love's allegations against undersigned counsel were proven beyond any doubt to be totally, knowingly false, and nothing happened. Yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. And then she does that here. I want to go through all these, but there's so many cases we can point to, or so many clips we can point to in this case that show just the blatant bias and just how Judge Glanville is allowing the state to do pretty much whatever they want to and say whatever they want to. Over Young Thug's objection, when the state was attempting to introduce the January 26, 2015 social media posting for co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the court that only Young Thug's voice could be heard on this video/audio, except for another voice saying the words like, yeah, in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several voices were audible on the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. She is throwing temper tantrums all throughout this case. Of course, Lawyer Love has proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that Lawyer Love falsely accused another member of the bar of misconduct/lying to the court did nothing to admonish Lawyer Love. And this happens over and over and over and over and over. I mean, y'all see the clips here, and we'll go through some of them. This pattern of permitting prosecutorial misconduct illustrates that the court wrongfully favors Lawyer Love and the state of Georgia in this case. And he's not wrong, man. He is not wrong at all. Let's see this clip real quick. He said 657 through 657 through 657:33. All right, let's see if we can find it.
And around January 26th of 2015, did you locate
Let's see if I can find it.
video, or did you locate a video posted around?
Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago,
Glanville, what are you saying?
What the public sees is, there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that we are not in collusion with one another. Justice is what it will be, and
Well, I don't know about that one.
whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put that.
Dude, look at him. He can't even say anything wrong about the state. Come on, Judge Glanville, man. This is wild. This is absolutely wild. Hold on. I might have to. What is going on with our? There we go. Jeez. Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Lil Woody. This was another knowing, malicious, false allegations by Lawyer Love. The court remained mute and failed to admonish Lawyer Love again. I mean, there's so many of these. Lawyer Love falsely accused counsel for Lil Woody of violating his ethical duty to his client. The court remained silent while Lawyer Love hurled more false allegations. Okay, and that's on June 7th. Of course, we just talked about that earlier where Mr. Melnick, he was the one who was saying, hey, if you think I'm not doing things in my client's best interest, then you know what. In the jury's presence on separate occasions, the court wrongfully accused undersigned counsel of being unprofessional as well as unprepared. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, and undersigned counsel was neither unprofessional nor unprepared. And we saw this in the video the other day. If y'all haven't seen it, you can definitely go back and watch that. The court's overly prejudicial and improper conduct towards Young Thug and or his counsel, and his refusal to instruct the jury to disregard these impermissible and false allegations, as well as the court's failure to apologize for the baseless claims, proves the bias of the state and the prejudice against Mr. William and his counsel. The above few examples raise reasonable questions concerning the court's partiality and bias against Young Thug and his counsel's efforts to obtain a fair trial and fair tribunal without prosecutorial misconduct. And again, this goes back to everything that we've been saying and everything that we've seen in this case, right? Brian says, anytime I say something or anytime I point out something that's been done wrong in this court, you're always siding with the state. And I can't speak up, and I can't properly defend my client, and I can't properly go through the proceedings without you letting the state or letting the prosecution do whatever they want to. And it's not fair on his part either. So there's a lot more here to go through. We'll go through a little bit more of it. And then I want to talk to y'all about this amended witness list as well, because this is going to be very interesting. And it's another chess move by our guy, the Honorable Brian Steele. All right, but let's keep going with this. The court's impartiality to objectively question to the court. This court's impartiality is objectively questioned when the court must be recused. The court has falsely and wrongfully accused undersigned counsel of being unprofessional and unprepared in front of the jury. Yeah, Judge, you can't be painting the defense like that. That's messed up. Neither claim has any modicum of truth. The prosecutor sat silent as the court wrongly and falsely accused undersigned counsel of improper conduct in front of the jury, all prejudicing Young Thug. The court has violated its duty of neutrality, impartiality that it was sworn to undertake. Even knowing that the court falsely accused undersigned counsel of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper, highly prejudicial comments. This conduct shows that the court is biased against Young Thug and his counsel and favors the state as no unbiased judge would not correct such a serious misstatement made in front of the jury. Man, Brian is ready to die on this hill. He does not want to be painted as incompetent, which again makes sense because the jury is going to look at him a certain way. Not only that, but his client too, as we talked about. And then there's another clip here from one that we played before. To date, the court has done absolutely nothing to stop Lawyer Love from continued misrepresentations, abuse of others, and false allegations. Instead, on occasion, the court speaks in generalities and reminds both sides, which y'all heard, to be professional. Now, guys, let's keep your hands to yourself. Brian Steele said, but she's the one who hit me. I didn't even do anything. I know, but we were all upset. Everybody's getting frustrated. You guys just remember to keep your hands to yourself. But she's already hit me like 6 times. I know. It's fine. It's fine. It's okay. It happens. People get upset. It's all right. Just remember, when we get upset, you got to keep your hands to yourself. All right? It's okay. That's got to be the most frustrating thing in the world. This is not a both sides issue, says Brian. This is a one-sided issue. Get him now. Resulting in prejudice of Young Thug and a violation of his constitutional rights to fair trial. Young Thug languishes in jail without bond since his arrest on May 9, 2022. Young Thug has been and is being denied his constitutional right to due process, a fair tribunal, and a fair trial based upon prosecutorial misconduct and judicial misconduct as well. The court has exhibited a pattern of bias in favor of the state and against Young Thug and his counsel, and the court has failed to admonish Lawyer Love to present their past and continuous misconduct. The failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. I mean, dang, she couldn't even get her response in on time. She doesn't give a fuck. Come on. Brian's not wrong. Now, and normally, and I want to be fair, again, I'm going to pull Judge Glanville and be like, now guys. And normally in this case, I would say, okay, Brian, we get it. You're piling on. He's not being fair. But I think it's very important for Brian to go through and point out exactly where he's seeing the misconduct, because the judge ruling on this is going to need to see examples, because if they haven't been following the case, if they haven't been watching the case, if they haven't, I'd be absolutely surprised. But you can go back and look at these instances where everything's Brian's saying, it's not based off of feeling. It's not based off of a cheeky response. It's based off of fact. Judge Glanville is saying these things. The state, the prosecution is doing these things. And Brian Steele was held in contempt. Brian Steele almost had to spend 20 weeks in prison because he wouldn't answer the judge's question. I mean, so I get it, man. He's got to put all of this in here because he is fighting an uphill battle, as we have seen. And we already know that Judge Krause has already denied one of the motions to recuse herself. So she said she's not going anywhere. We'll see what happens. I have a very strong feeling that all of this is going to go to the Supreme Court. But with that being said, we're not going to read through the rest of this. I'll have the link to this document in the description of the video for y'all. I wanted to point out one more thing. Again, Brian Steele, he is on the offensive. He is going at Judge Glanville and is doing everything he possibly can to make sure he gets him off of this case. Most recently, right after this, y'all see, let me pull this back up on the screen. Y'all see he filed this motion for a fair trial at 4:38 yesterday. And then he also filed, I know y'all can't see it. Here we go. He also filed this, defendant Jeffrey Williams, aka Young Thug's 8th amended list of witnesses. He filed this at exactly the same time. All right. And guess what? Guess what this is? I'm going to read it to you guys. Comes now, Young Thug, by and through undersigned counsel, and hereby files this witness list in the above referenced cases. All right. And they're updating the witness list here. We've got some interesting people. We've got Miss Samaya Barnes is in here. That's cool. We've got Mr. Crenshaw is up in here. Uh-oh. We've got Detective Scott is in here as well. He's a cell phone expert. Interesting. Uh-oh. Who do we see down here that got added to the witness list? Oh my gosh. Judge Earl Glanville. Yep. Who else do we have in here? We have anybody else interesting? Let's see. Let's keep going. We got Mr. Rotman, Mr. Smith. We got a bunch of other people. Okay. Nobody too interesting. Now, why is this important that Judge Glanville is on this witness list? Well, the issue is if Judge Glanville gets called as a witness, who's going to proceed over this trial? Judge Glanville can't be in two places at once. He can't be on the witness stand and presiding over this case. So with this being said, what's going to happen is they're going to look at this updated witness list and they're going to have to decide if what Judge Glanville has to say is going to pertain to this case. If they decide that in fact is the case, they need to hear what Glanville has to say, then he has to be removed. He can't be on this case anymore. So again, Brian Steele, he's making so many chess moves in this case because not only is he trying to get the judge recused based off of motion to recuse, the supplement to the motion to recuse, but now he's saying, I'm going to call him as a witness as well. So that's 3 instances where he's saying he's got to go, he's got to go, he's got to go. So again, I'm not sure if it's Judge Rachel Krause that is actually going to have to rule on this updated or amended witness list, but another judge is going to look at this. And if they find that Judge Glanville has something to say based on this case, then they got to get him up out of there and get him off the stand. So y'all let me know what you think about this. Brian Steele out here making moves. The Honorable Brian Steele. Let's put some respect on his name. Lawyer of the Year. Is this going to work though? What's going to happen? Judge Krause going to do the right thing? Is it going to be up to the Supreme Court? Y'all let me know what you think in the comments.